So the first actual provision of Australian consumer law we're going to look at is misleading and deceptive conduct, section 18 of the Australian consumer law. This is a really critical piece of legislation that affects most, if not all, businesses. And it's such a simple piece of legislation that it's really useful for us to look at from two perspectives: its applicability in business and also how the law works and how to think about how legislators phrase legislation and the impact of the way that they phrase it. So let's get into section 18. So section 18 says a person must not, in trade or commerce, engage in conduct that's misleading or deceptive or likely to mislead or deceive. Okay, so let's break this apart. We've got a person, and we know that that includes companies, right? Because companies are legal persons. Must not, in trade or commerce, is one requirement. There must be conduct. They've got to do something that's in trade or commerce. And 3, it's got to be misleading or deceptive, but it actually doesn't need to be misleading or deceptive. It can be likely to mislead or deceive. So you don't actually have to have deceived anyone. And if you do that, you've breached section 18. Now, what's even more interesting is that someone who suffers loss because someone contravenes this section can bring legal proceedings. So what that means, that actually means that competitors can sue each other, right? Because they can argue their competitor took market share, right? So this is a way that industry self-regulates itself into not making misleading or deceptive statements as part of their business marketing. In addition to taking action themselves, they can lodge a complaint with the ACCC, the regulator, who we learned about in the last video, who can then take the legal action. So as we've just been saying, section 18 doesn't only apply for consumers in order to protect their interests, but interested members of the public or other businesses, including competitors. And Gillette and Energizer Australia are an example of that, about the way that batteries were portrayed in advertising as to the length of time they would last. What's also really important to understand about misleading and deceptive conduct is intention is irrelevant. So what does that really mean? They don't have to mean to mislead or deceive. Okay? They don't have to mean it. But if they say something where that would occur, then they've breached the provisions. So you can act honestly and reasonably and still breach this provision. Why? Well, because it's written so broadly. It just says you're not, when you're in trade or commerce, to engage in conduct that's misleading or deceptive. It doesn't say you have to intend to. It just says if you do it, right, you'll have a problem. As we've said, section 18 you can break down into 3 key elements. There must be conduct. That conduct must be in trade or commerce, and that conduct must be misleading or deceptive or likely to mislead or deceive. So what does conduct actually mean? Well, conduct is held to be interpreted very broadly. In fact, conduct can be doing nothing if it gives the impression to someone else that misleads or deceives them. So for instance, in Hangzhou Investments, you had a company who was negotiating the sale of a restaurant to another company, Collins. When the representatives from Collins came in to look at the restaurant, there were seats for 128 people. However, the restaurant license limited the seating capacity to only 84. Right? So they put more seats and tables there in the sidewalk, etc., than what they had a license for. So when Collins learnt of the limit, they instituted proceedings that what Hangzhou had done was misleading or deceptive. And the court decided that Hangzhou's silence about how many seats there were was misleading or deceptive, right? The fact that they'd set them out, then Collins came in, had a look around and says, gee, 128 seats, and they didn't say anything. That left Collins with perception that there were more seats, so they were misled or deceived. So conduct is very broad, making a statement, making a claim, making a promise, not saying something that's literally true, right, can be misleading and deceptive under certain circumstances. So as long as there's conduct, as long as they're doing something, we'll have met that element. The second element is a little bit easier, right? That conduct must have been in trade or commerce. So it must have had a trading or commercial character. If it's in a non-commercial context, it's not a breach of Section 18. So what aren't examples of a trade or commerce? Okay, so political activity is not trade or commerce. Education is not trade or commerce. So for instance, giving a lecture is not considered trade and commerce. A public lecture where you don't pay for it, where people can come along, right, is not in trade or commerce. Promises made in an election campaign are part of democracy and being elected, not trade or commerce. And that's why certain assurances can be made by politicians without breaching Section 18. But generally, if it involves business, it's going to be in trade or commerce. Now, where it gets a bit tougher is what is misleading or deceptive conduct, or conduct that's likely to mislead or deceive. The case that helps us understand that is Taco Company of Australia and Taco Bell Limited. So in this case, we've got a restaurant in Sydney owned by Taco Bell Proprietary Limited, and they've been operating under the name Taco Bell for quite a long time. Now, you may know that Taco Bell, the chain of restaurants from the US, has just opened, but this goes back to the late 70s, early 80s, and at that time, that company wasn't operating in Australia, and they set up here. So Taco Company of Australia Incorporated, which was the US restaurant chain, sought to open a restaurant with that name. And they commenced an action against Taco Bell, who had been operating separately in Australia with that name, alleging a contravention of the same provision under a previous piece of legislation. Taco Bell, the Australian company, cross-claimed, right, alleging the same thing. The court decided that since Taco Bell, the Australian company, had commenced operations in Australia first, it was the American company that was engaging in the misleading or deceptive conduct. Now, quite apart from the decision, the interesting thing here was the court came up with a test for determining whether conduct would be misleading or deceptive. And there's a number of steps that we need to go through. First, you need to identify the section or sections of the public which the conduct is aimed at, right? So therefore, you don't look at the average person. You look at who, if it's an ad, who is the ad targeted at? If it's sales behavior, who are the salespeople are targeting with their behavior? Okay, so you're looking at the target section. Once you've got that target section, the next thing you need to think about is all of the people who are in that section, including the astute and the gullible, the intelligent and the not so intelligent, the well-educated, poorly educated, men and women of various ages pursuing a variety of vocations. So what does this mean? Again, it's not an average person test. It's actually saying, would a proportion of people in this target group be deceived? Even if they were gullible, even if it took a gullible person to be misled or deceived, is there a number of them who in this target group who would be misled or deceived, or likely to mislead or deceived? And if so, it's misleading or deceptive conduct. So really, that's quite a low bar in terms of misleading or deceptive conduct. So to get very practical, if we had an ad that was directed towards children, it'd be treated and assessed quite differently to an ad that's, say, directed towards, doctors, for instance. Okay, so Furthermore, convening Section 18 only needs a small percentage of the target to be misled or deceived. Not most of them, not a large group, just some small percentage. More than one or two, but a few, several. If several people could be misled or deceived. So again, it's quite a broad interpretation of misleading or deceptive conduct. And as I was saying before, a statement that's literally true can be misleading or deceptive if a business presents that literal truth in a way that the overall effect is misleading or deceptive. That doesn't necessarily mean, however, that a statement that's not literally true is necessarily misleading or deceptive. Okay, so courts will tolerate sales puff, such as soft drinks giving people wings. So what kinds of things might be misleading or deceptive that are practically true? Okay, in Henderson and Pioneer Homes, we had a newspaper ad for a house and land package that advertised a low weekly repayment rate in large print, but a statement in fine print that said that low rate was for 1 year only and would later be increased. The court decided the overall impression created by the ad was misleading, even though the ad contained all of the correct information. In Given and Pryor, a proposal for subdivision had the phrase or statement that it was a wonderful place to live. The court decided here that while that was an exaggeration and you might normally think it as sales puff, it was actually misleading and deceptive conduct here, because the zoning of the land meant you actually couldn't develop dwellings, so you actually couldn't live there. That's what made it misleading and deceptive, not the wonderful place to live puffery element of it. And in McWilliams Wines and McDonald's, we start to see some of the limits of what is misleading and deceptive. McWilliams Wines released an extra large 2-litre bottle of wine that they marketed as the Big Mac. McDonald's then took out a civil action against McWilliams, saying, look, you've breached misleading and deceptive conduct provisions because people might think it's a McDonald's wine. And the court said, look, some people might be confused, but really there's no connection between hamburgers and fries and wine. And so this isn't the same. And this confusion that might be in people's heads is not the same as being misled or deceived. So what happens if you breach Section 18? Well, we can get an injunction, which would require the business to stop that conduct, stop that advertising campaign, those statements, whatever they're doing. You could get damages if you've suffered loss as a result of the misleading or deceptive conduct. And you could get orders, kind of like a specific performance element, right? Section 246, orders requiring the business to comply with Section 18 and educate their employees. So these remedies, you can see, are wider than what you'd normally get at common law for misrepresentation or breach of conduct, because it's also easier to establish misleading or deceptive conduct. People are much more likely to use this provision than they are misrepresentation or breach of conduct if they can get it under this kind of behaviour. Okay, so that's a critical element of the modern business environment that we have in Australia. Misleading and deceptive conduct, really important for all areas of business, maybe even more important for those doing advertising and marketing. Next, we've got consumer guarantees.